Hello and welcome. I'm Lisa Almo, Community Relations Representative here at the Lakeshore. Before we start today's presentation, I would like to share with you a little bit about our beautiful community. Many of you have perhaps visited the Lakeshore previously. For those of you who are less familiar, I would like to share with you that we are a premier retirement community that sits on the south shore of beautiful Lake Washington. We have 156 senior apartment homes offering a variety of studio, 1-bedroom, and 2-bedroom floor plan options. Right now, we are moving new residents into our community, and we are able to do full in-person community tours. If you are interested in learning more about the Lakeshore, interested in a tour, or making a reservation, please feel free to contact Jane, Alicia, or myself in the Community Relations Office. I also want to share with you and have you be aware of an extraordinary partnership that the Lakeshore and Era Living's other 7 communities have with the University of Washington. Our residents benefit from this partnership to deliver innovative programs designed with healthy living in mind. The partnerships lie with the School of Pharmacy, the School of Social Work, and the School of Nursing. For nearly 3 decades, Era Living has pioneered a powerful relationship with top-ranked University of Washington School of Nursing. The partnership allows residents to benefit from evidence-informed wellness and active aging programs. Now, before we get to the main event, I'd like to tell you a little bit about our presenter, Elizabeth Jennings. Elizabeth is an associate attorney at Northwest Elder Law Group. She received her bachelor's degree magna cum laude from Clemson University and her law degree from Boston College. Elizabeth's practice areas include estate planning, probate, and guardianship. And now it's my pleasure to introduce to you Elizabeth Jennings.
Hello. I'm happy to be here. I'm happy to talk to you all about planning and how helpful it can be. So if you're here, that's kind of the first step. You're thinking about these issues. You're starting to kind of make sure your ducks are in a row. And so I want to go over kind of a basic overview of maybe what you should be thinking of so you can feel confident that you've kind of checked those boxes. You are doing appropriate planning for what fits your needs and reflects your wishes. So as mentioned, I'm going to be kind of talking about a couple different areas related to planning and estate planning, but feel free to add your questions in the chat. I'll kind of check in throughout the presentation, as well as towards the end, we should have some time for questions. So when I think about planning, and particularly estate planning, I kind of break that up into 3 areas. I think about planning for death, which may not be the best to think about, but primarily how we plan to pass on wealth or assets or provide for people or, nonprofits that we care about, but also planning for periods of incapacity, right? If thinking about, is there a time where you may not be able to make your own decisions? Kind of what kind of structures and protections can you put in place in advance? And then I think the most fun to think about is planning to live a long time, right? You're retired, you're loving life. We want to make sure that financially you are supported during that time. And as needs potentially increase, can we pay for them? So I like to think about planning and making sure all your ducks are in a row in these 3 main categories. So nothing better than a sunny afternoon to start off talking about planning for death. So again, I know it's not something that a lot of people like to think about or plan, but the more you think about these decisions now, the easier it can be on your family members, your loved ones down the road. And I like to think about planning for death, more so planning for gifting. Because if you have worked hard during your lifetime, you have people and things that you care about, and maybe want to provide for them even after you're gone. So when I think about estate planning, it's what kind of structures, what kind of steps can you take now to make sure that you're passing on wealth or gifts to the loved ones in your life. So that's kind of the mindset I go into estate planning with. I also recommend kind of one thing you can do right now, sitting in the comfort of your home when it comes to planning, is think about what you own. What is in your estate that could potentially be gifted at your death. And within your estate, you should think about, there's kind of two categories that those assets fall in. Some are considered non-probate assets. So those are the things that you own, financial accounts, property, where you've already designated someone to receive that asset once you pass away. So things like beneficiary designations on your retirement accounts, those are considered non-probate assets because they are an asset that is going to transfer to your designated beneficiary outside of your will, outside of possible probate. So as you're kind of looking at your finances, looking at your assets, start to identify what's in this non-probate pot, and then what's considered a probate asset. What are the items that you may own that don't have a designated beneficiary? That's going to be covered by your will or your trust or the estate plan that you put in place. So that's one of the first steps when I'm working with clients is let's get a snapshot of what you own and how you own it. Do you have a beneficiary or not? And that can kind of help us plan. So if you think about your own assets and things that you own, you probably already have some non-probate assets out there. So non-probate assets are things like bank accounts or even real estate that you own as joint tenants with right of survivorship. That's a form of ownership where kind of the co-owner who outlives the other gets full ownership. You can designate beneficiaries on bank accounts, retirement accounts. We even have options for real estate. For example, Washington allows what's called a transfer on death deed, that you can record a deed now that doesn't have any effect while you're alive to gift your property to someone in particular. So there are lots of non-probate assets out there that you usually can plan for, designate, make updates to those beneficiary designations now without maybe needing an attorney and witnesses. So it's kind of helpful to think about what you own. Do you have any of these non-probate assets? Along those lines, I always get questions about avoiding probate. So I'll frequently get calls from clients saying, Susie Orman told me I need a trust. I need to avoid probate. It's horrible. I am here to tell you, don't be as concerned as Susie Orman is about probate if that is something that your loved ones have to handle if you've passed away. All probate is, particularly in Washington, is a process where the court gives someone authority, an executor or a personal representative, to handle your affairs. So to make sure that your debts are paid, make sure that your assets are distributed to the persons or the groups of people that you want. And the best way to make probate easy for your loved ones is to plan, right? Have a will in place, have these documents in place where it's really clear what you want and who you want to be in control of those kind of decisions or next steps. So in Washington, probate isn't quite the horror story that sometimes it's made out to be. Some states it can be. But again, the best way to make sure that probate is easy and efficient is to plan. So with that said, one tool that doesn't always get mentioned, but I think it's worth bringing up to make your estate and providing for loved ones really easy is if you are married, having a community property agreement. So even though Washington is a community property state, right, everything you accumulate with your spouse during marriage has this label of community property, you can make the transfer of your assets to your spouse, your community property to your spouse, a lot easier if you potentially have a community property agreement, or sometimes called a community property survivorship agreement. It's a pretty short contract between spouses that just says everything I own at the time of my death, that's going to be considered community property. And when I pass away, I want to make sure that all of my community property goes to my spouse. So it's a really nice way to kind of simplify the passing of assets and changing names on title so that you're providing for your spouse in a way that you can eliminate the need for probate. So kind of put that in your toolbox as a potential option if you are married and maybe want to simplify your estate plan. This isn't a fix-all though. So community property agreement is helpful to simplify things between spouses, but it doesn't completely eliminate the need to do some estate planning. It may also not be the best option if one spouse may have some increased care needs, maybe needs to qualify for Medicaid down the road, or maybe you are lucky and have a very large estate. It may not be a good option to avoid estate taxes. So keep this in mind though, kind of look through any estate planning documents that you currently have and consider whether a community property agreement may be part of the planning you want to do. So beyond planning to gift to a spouse, the document that people are most familiar with when we talk about estate planning is a will. So anyone can make a will, any legal adult that has capacity, they are of sound mind. So this is something that if you haven't taken the time to put a will together, it's worth doing because again, it makes sure that your wishes are known to everyone. It can make the process of settling your affairs a lot easier. And a will doesn't have to be a super long, complicated document, though it certainly can be if circumstances warrant it. But any adult can make a will, and it provides for what is going to happen to your estate. In Washington, a will does have to be in writing, has to be signed by you, the testator, the person making the will. And your signature needs to be witnessed by two disinterested witnesses. So this was something that was a little bit tricky, especially in the early days of COVID, as people were maybe anxious to get their estate planning in order, but we couldn't be around other people. So now as things are kind of opening up, this is more of an option. Make sure you have witnesses that are available. They can attest that you have capacity, you intend this document to be your will. And they can also sign what's called an affidavit or make it a self-proving will so that years into the future, if your will ever has to be admitted to probate, we don't have to go track down those witnesses. If you have an existing will, this is a good excuse to kind of dust that out, pull it out of the file cabinet or wherever it has been for the last decade or so, and kind of go through the provisions, make sure that it still makes sense for you and that it reflects your wishes. So some common things that you'll see in a will, it should identify who you are. It usually will identify your immediate family. If you've made any prior wills or codicils, which are like amendments to a will, your new will should revoke all the prior ones. And then we start to get into the gifting component. So one thing that's nice about the state of Washington is we have a statute that says, essentially, if you reference in your will or trust that you may have a separate writing reflecting gifts of tangible personal property, then you can maintain and update and add to that list without having to change your will. So if your will or your existing estate planning has a paragraph about this separate property list, it's kind of a nice tool that you can do and kind of plan in advance. It's a more formal way than my grandmother. She would say everyone gets a different color Post-it note, put the Post-it note on what you want in the house. This is a way that you can think through if there are particular pieces of jewelry or family heirlooms or items that you want to make sure go to a specific person. You can add to that list, update it as often as you want without having to update your will. Otherwise, everything that's not on that list can be kind of grouped into the bequests or the gifts that you're going to make in your will. You can always give specific items to people, specific dollar amounts, specific pieces of property, or you can give the rest, residue, and remainder, which is a fun legal phrase that just means everything else that's left, right? After all the bills are paid, how do you want to divide your estate? All to everyone or all to one person, splitting up by percentages? Start to think about what documents you do have in place and make sure that they express your wishes and reflect what you want today. You'll also see your will should have some sort of nomination of an executor or personal representative. This is the person that you trust to carry out the terms of your will. So this is where I say, start to think about the people in your life and your people in your life now that you trust to make sure that your final wishes are carried out. So this is a good excuse. Maybe if you did your estate planning decades ago, who did you name as your executor? Is that person still in your life? Is that still someone you want to trust? If not, good time to update those documents. And usually you'll see reference that executor has the authority to carry out your wishes with non-intervention powers, which means if your will has to be probated, they don't have to keep going back to court for permission. The process can move really smoothly, which is one of the reasons that probate in Washington can be pretty efficient. You do have to sign your will and date your will. And again, sign in front of those two witnesses. They should sign the will itself and sign a separate affidavit of attesting witnesses, where basically they are swearing they saw you sign the will, you intended this document to be your will, you don't seem to be under any undue influence or duress. So it provides a little bit of verification to the will itself. The will does not have to be notarized. Doesn't hurt, but it's not a requirement in Washington. Another component of estate planning that starts to get a little bit more complex is trusts. So again, I have clients who think, do I need a trust? I don't even know what a trust is. Trusts are just a mechanism where you can maintain a little bit more control over the gifts that you're giving, right? So maybe you want to provide for a grandchild who's 5 years old right now. That grandchild who's 5 years old can't really inherit a large estate, right, until they turn at least 18. Well, I don't know a lot of 18-year-olds that I would trust receiving a large, sum of money. So maybe you want to specify how that money can be used for that beneficiary. So trusts are just a way to maybe spread out distributions or to provide guidelines for how you want your beneficiaries to receive the benefits of their inheritance. So there are lots and lots of kinds of trusts. We could spend hours just talking about trusts, But I just want you to keep this in mind that it's an arrangement, whether in a will or as a separate document, that just provides who you want to gift to and who do you trust to manage that gift for the recipient. So it's an arrangement where you designate a trusted fiduciary, a trustee, to hold on to assets for the benefit of a beneficiary. And I always have people ask me, do I need a trust? Does it make sense for my situation? That's definitely something I usually recommend you talk to an attorney about. But you can start to think about your own situation, your own family members, how you want to gift your estate, because trust can make sense in several different scenarios. As I mentioned, maybe you want to gift to a minor, or maybe a irresponsible individual. Maybe you want to gift to someone who is receiving certain government benefits that are needs-based, and you want to protect those assets from disqualifying them from certain benefits. Maybe you're a super private person and you don't want your will to become part of the public record because probate is a public proceeding, and a trust administration is not. Maybe you own property in several different states. Maybe you have a blended family. Maybe you have a large taxable estate. There are lots of reasons why a trust may make sense to you. So everyone's different. Again, I recommend getting a handle on what assets you have out there, who you may want to gift to, and kind of what are your primary concerns. And talk to an expert, talk to an attorney, or kind of talk over these issues with your loved ones. That's my big piece of advice, is have these conversations early, and often if you can. So along the lines of concerns about taxes, I always get questions of, I want to make sure that the government doesn't get all my money when I die. I want it to go to my loved ones. So one thing to keep in mind is that both Washington and the United States, we have exemption amounts that specify how much you can give during life, for under federal law, and particularly under death, for federal law and state law, that there are certain amounts you can gift without any estate taxes, or sometimes they're referred to as death taxes. They're pretty high thresholds currently, especially for federal law. Anyone can pass up to $11.7 million without federal estate taxes. So that's kind of a nice cushion. Washington state, our threshold is a little bit lower, or a lot lower. But there are exemptions for gifts to your spouse, to charities, to certain political organizations. You can gift to those people, to your spouse, without any estate taxes, no matter the amount. But if you start to fall, kind of above these thresholds, either at the federal or the state level, that's usually a good indication that you may want to pull out any current estate planning documents that you have, or talk to an attorney about updating those or putting new ones in place to potentially address estate taxes down the road. So lots more to talk about with estate taxes. I wanted to kind of pause here, see if there's any questions at this stage before we move into kind of our next area of planning. Okay.
I don't see any in the chat box.
Okay. Oh. Ooh, so I do have a question.
Here's one.
Yes.
How is probate initiated?
That is a good question. So probate is a court process. And I could, again, talk for days about probate. But probate is initiated with an original will, if you have one, or if someone passed away without a will, you can still open probate. And it's asking the court to admit that will to probate, and who to appoint as the personal representative. So it's definitely a process that you can do on your own with a little bit of research. There are some good resources out there. for free online through like the King County Law Library, or something you may want some guidance on with an attorney. But it's a handful of documents to be submitted to the court that would show that you are the executor or the personal representative with authority to handle someone's estate. So probate is usually a little bit of a burden at the beginning. To initiate that probate, file the petition and the will and the oath with the court. And then once the court approves you as the executor, they issue what are called letters testamentary. And that's kind of your official verification that you have the authority to carry out the deceased person's final affairs. So I could present on that for days, but feel free to send me any questions after the presentation if you do have specific probate questions.
And there's another question. It says, giving to political parties is not deductible now, so how can it work after my death?
There are certain exemptions as far as who you can gift to, depending on how they qualify under the IRS. So there are some, maybe not political candidates that you can gift to, but some nonprofits, some organizations that may carry out certain activities, but are still qualified as exempt organizations that you can gift to. So if you do have a taxable estate and you do want to gift to certain organizations, certain individuals to help reduce the estate tax, definitely something to talk to your CPA about, talk to your attorney about, to kind of make sure that all the pieces of that puzzle fit together correctly, to avoid those estate taxes and make sure that more money gets to the people and organizations that you want them to. And know that the tax laws are always changing. So kind of be on alert for that. We always try to plan for every eventuality down the road, but we always keep an eye on new laws that are being proposed as they may affect clients and kind of how they want to handle their estate. So the work never ends. Okay, so now I want to jump into a different scenario to plan for, which is planning for incapacity or disability. And when I'm talking about planning for those situations, I'm primarily talking about powers of attorney and advanced planning, advanced directives, healthcare directives, right? Putting your wishes on paper now and designating people you trust who are able to step in and decisions be made if there's ever a period where you can't make those decisions for yourself. Because if you have a will, right, that will only has legal force and effect after you're gone. So I think a lot of times people think, oh, I've got a will, I'm good. But really, you also want to think about putting a power of attorney in place. And a power of attorney can be really helpful, whether there is a permanent or temporary period of incapacity, right? Unfortunately, as we age, some people experience dementia or Alzheimer's, or maybe they are unable to make their own decisions at some point. Or maybe they have a medical condition that makes it hard for them to manage their own affairs. That's where a power of attorney can be really helpful. That can help your trusted individual be able to step in and kind of step into your shoes when you are unable to act yourself. So that big document kind of covers a whole bunch of different scenarios. You'll refer to as a power of attorney or a durable power of attorney. And it's a written document that explains a relationship between the maker, the principal, and your attorney in fact, or your agent. Who do you designate to stand in your shoes, kind of take over where maybe you can't continue yourself? You can have powers of attorney super broad for financial and healthcare decisions. You can have powers of attorney that are really narrow for a very limited purpose or duration. I had a client who was stuck abroad during the beginning of the coronavirus. And him and his wife were in the process of selling their house. So he did a limited power of attorney so that his wife could sign his name on kind of all of the real estate documents. So powers of attorney can be really flexible. In Washington, we have a statute. So under the Revised Code of Washington, Title 11, Chapter 125. If you're ever bored, a little light reading, you can start to look through the laws and the kind of baseline powers that you can give an agent under a power of attorney. So that's kind of a good first step. If you don't have a power of attorney right now, kind of go through that authority, see how comfortable you are with giving another person potentially those types of powers.
So we have a question regarding power of attorney.
Yes.
It says, if one names a professional fiduciary company as power of attorney or trustee in a trust, can that company change grantor's investments, decide to sell grantor's house, and put grantor in assisted living if grantor is incapacitated? Who makes that decision?
Good question. So that's why we're here, right? Because the goal with this planning is so that it's very clear in your power of attorney, in your trust, that your wishes are specified and honored. So the more that you put in your power of attorney to express what you want or what you don't want, your designated fiduciary or agent, whether it's a friend or a family member or a professional, they first have to look to that document for guidance. So sometimes a power of attorney may say, you know, my priority is to stay in my own home as long as possible. And I authorize my power of attorney, my attorney in fact, to devote all of my resources to that end. Again, it gives your designated agent that guidance, because your fiduciary, their job is to carry out your wishes to the extent that they know them. If they don't know them, then they have to kind of guess what you would want or think about what they think is in your best interest. So the more, you know, you can plan and put your wishes on paper, the more control you can have over those decisions, even if you have lost capacity. There are limits to what a power of attorney can do under the law. They can't force you to go somewhere you don't want to go or to move somewhere you don't want to. As long as you can express your wishes, again, they do have to honor that. So that's where, again, thinking about where your priorities are, what you do or do not want, really important to start to integrate those into a power of attorney or other estate planning documents. And it's also important to think about who you trust to be your agent, to have that authority, right? Have those conversations with family members or friends who you are considering naming. Do you think that that person is going to carry out your wishes to the best of their ability? And if there's not a friend or a family member that you feel comfortable designating, as the person who asked the question mentioned, you can pick a professional fiduciary. So there are lots of organizations through banks, through private organizations, through nonprofits, that they are professional fiduciaries that you can essentially pay or hire to act as your attorney in fact, to act as your trustee if there's ever a point that you can't act for yourself. I always recommend build in as many alternative agents as you feel comfortable with, right? If you only designate one person and that person passes away or is unable to act or is just unwilling, then we look to the document, who's the alternative? And if you become incapacitated, you can't manage things on your own, and you haven't designated an agent or a backup agent, then that's where courts have to get involved, potentially through a guardianship, which not ideal. So again, plan now and avoid, hopefully these issues down the road.
Okay, another question. Can named successor trustee delegate managing parts of my estate to a fiduciary if fiduciary is not listed in trust?
Yeah, usually powers of attorney or trust documents or estate planning will authorize your designated agent to hire professionals or to delegate as need be. So it could be that you give your agent the authority to hire, in-home caregivers, or hire attorneys or tax accountants. They can be granted that authority to delegate some of the day-to-day or the bigger tasks to other people. Again, a power of attorney is really governed by statute. Yes, that's kind of the default, but you can build that document to be something that you're comfortable with, and that reflects the authority you want to give your designated agent. So that's the moral of my story today is plan, put it on paper, make sure that your wishes are very clear to everyone, and that's the best way to get them honored. Another thing to keep in mind if you have a power of attorney or you need to put one in place is that you can make it effective only upon your incapacity, or you can make it effective as soon as you sign it. And so this is an area I have a lot of clients struggle with or think about. They think, well, I want to be able to handle things on my own until I'm completely incapacitated. That's great. But sometimes designating your power of attorney effective immediately can be really helpful. It doesn't take away your ability to act. It just gives your agent concurrent authority to act on your behalf. So especially if you are naming a really trusted individual, maybe a spouse or a child, a sibling, if you trust that person, you may want to make it effective immediately. So you can tell them, hey, I'm lazy today, go to the bank and write that check for me. Again, it doesn't limit your ability to act and make your own decisions. It just gives someone else immediate authority to step into your shoes if needed. Otherwise, powers of attorney are usually springing. They spring into action upon some occurrence of an event. And so a lot of times those powers of attorney are written so that they are only effective, if one or more physicians have found that you are incapacitated or unable to manage your own affairs, which is a nice layer of protection, but can also be a little bit burdensome, right? If there's an emergency, someone needs to step in. Are they going to have to go find two independent physicians who are willing to put on paper that you are unable to manage things on your own? So something to consider as you think about putting a power of attorney in place or updating what you currently have. When is it effective? And how are you, what's your comfort level with the options? Powers of attorney do need to be in writing. And as I said, there's kind of these default powers by statute, but you can always modify them in writing in your power of attorney. You can expand them. You can give super broad powers or more limited powers. That power of attorney needs to be signed in front of a notary, but there's also an exception to allow for witnesses instead of a notary. I do recommend, though, ideally have that power of attorney notarized, especially if it is for financial authority. If someone needs to step in and sell your house on your behalf, most title companies want to see that power of attorney was notarized, not just witnessed. They make it a little bit difficult on you. As I mentioned, you can have one big, broad power of attorney, or you can have specific powers of attorney for specific kind of tasks. So a financial power of attorney can cover everything to do with your property, your assets, paying bills, making sure your medical expenses are paid, buying and selling property, handling your investments. Again, that person has the authority that you want to give them. You can also have a power of attorney for healthcare decisions. So your designated agent under a power of attorney for healthcare, basically, if your care team, if your doctor believes you cannot appreciate the decisions that you are being asked to be made about your own healthcare, you designate who you want to give informed consent for treatment on your behalf. If you don't have a healthcare power of attorney, Washington does have a statute that's like the default, and it kind of goes out on your family tree, right? It's your spouse, it's your adult children, or your parents or your siblings kind of going out from there. So if you don't have a healthcare power of attorney, care professionals at least know who they can turn to. But maybe you don't want your long lost sister to be the one who has to answer the call and make a decision about your health care. So that's where putting your wishes on paper is really helpful. And where Washington has a default kind of order of priority for healthcare decisions, there's no equivalent for financial decisions. So if you don't have a power of attorney that grants financial authority, you're out of luck. Or someone may have to petition for guardianship on your behalf. So plan now and avoid that heartache down the road. Another component of advanced planning, particularly for periods of incapacity, are healthcare directives. So I won't go into too much detail about these, but this is a super helpful document so that you are telling your agent, you're telling your healthcare providers, you are deciding in advance for certain end-of-life decisions, right? If you are in a permanent coma or in an emergency situation, you have a terminal illness, what type of treatment or interventions do you want? Things like artificial nutrition and respiration. Washington, again, is great. We have kind of a very basic healthcare directive within our state statutes. You can kind of copy and paste that, sign in front of two witnesses or in front of a notary. There's also some great resources online. Your medical provider, right? If you call up your doctor or the hospital that you get care through, they probably have their own healthcare directive form. There's some great nonprofits out there. End of Life Washington is a great one that you can get some sample healthcare directives. There's also what's called like a POLST form. That's usually something you complete with your doctor. That's more in emergency situations. But the whole goal of an advance directive is, again, that your trusted agents, your family members, your friends, your medical providers, they're honoring your wishes. So to the extent you've put those wishes on paper or you've shared them with loved ones, that's going to mean that they're more likely to be carried out than if people are just left guessing about what you would want. So plan now while you're healthy, doing well, so that there's no confusion in an emergency. So before I get to my last and most fun component, any questions about powers of attorney and advance directives kind of along those lines? I don't think I see anything in the chat. Okay, well, I'm just going to jump into it then. So we've planned for death. We've planned for incapacity or disability. Now we get to think about planning to live a long time. And so that's fun, right? But also having to think about how do we financially support, the second half of our life. And I like this cartoon, right? Maybe the plan is, well, that's why I had kids. They can take care of me. But maybe you don't want to go live with your children. Maybe you want to live in a beautiful place, retire, kind of have a nice view. So planning to live a long time, planning to pay for long-term care is also an important consideration. So that's why an attorney like myself, if you come to me and you say, I want to do some estate planning, I may ask you some invasive questions about your finances, about your long-term care needs to the extent that you know them, your preferences, right? Where do you want to retire? What type do you want to live in? A nice retirement community, assisted living facility? What are your options? What are your preferences? So there's a little bit of guesswork, of course, because no one knows what's coming down the road. But financial planning is part of the long-term care planning process. So that's where it's important to start thinking about what are the assets you have available to pay for your care? What's your current health status? And do you have any diagnoses that may indicate your care needs are going to increase as you age? So taking a look at that kind of full package, what income is expected? What retirement benefits do you have, and when do you want to take them? Probably, again, if you're at this presentation, you've already started thinking about these things. What are your preferences for where you want to live? Where do you want to retire in a community that you've picked out? Or are you just going to hope that things are going to work out and maybe someone else is going to have to step in and make those decisions? Do you really want to make sure that there is something left for your loved ones that you want to gift to children or family members or friends after you're gone? Or if you're like my husband, he always says, I hope the last check I write bounces. So that's one way to look at it. But looking at the big financial picture, that is part of this process. I also have clients that talk about maybe wanting to qualify for Medicaid to pay for some of their long-term care costs. And there are strategies to kind of financially plan if Medicaid is something that makes sense for you and your future needs. But I always caution people, consult with a qualified attorney regarding Medicaid planning. There right now, if I decide in 5 years, I want to make sure, or, I need to qualify for Medicaid soon. They're going to pay for my long-term care costs. I'm going to gift everything I have away so that I have nothing left and I qualify for state and federal benefits. Well, the state and federal government will look back a full 5 years. Did you give away assets? Did you transfer things for less than fair market value just so you could qualify for Medicaid? That's a big penalty, a big no-no. So doing this financial planning, whether it's Medicaid planning or not, super important to plan early and plan often as circumstances change. So all of this is to say that, yes, there's a lot maybe on your homework or to-do list as you plan. But the more you plan, the earlier you plan, that's going to make the process so much easier if you do encounter these issues or periods of incapacity. So plan early, plan often. Some things you can do now, primarily from the safety of your home. Talk to your loved ones or your trusted agents about your wishes and priorities. Think critically about what you want, and express those to the people who may be in a position to make those decisions for you if you're unable to make them yourself. Think about what assets you have, your resources, and did you designate beneficiaries decades ago, maybe before you had kids or grandkids? Maybe it's time to update those beneficiary designations. If you have estate planning documents that you've done before, this is a good excuse. I know the nice weather doesn't make it easy, but maybe on a rainy day, pull out your current estate planning documents, really read through them, right? Do they still reflect your wishes? Are you gifting to the people that you really want to provide for? Who have you designated as your executor or your backup executor or a power of attorney or the backup? Are those people still in your life? Are they still people that you trust to honor your wishes? And do those people know that they are designated? That can be a little bit of a surprise, right? Maybe there's an emergency and someone gets a call from the hospital. It says, oh, you're designated as their healthcare power of attorney. What do you want to do? So having these conversations now, again, can make things go a lot more smoothly, potentially down the road. Another step I recommend you plan for is know where all your important documents are and make sure that your trusted fiduciaries know where to find them. You know, a will or a power of attorney or an advance directive, they're not really helpful if no one can find it. So things like your healthcare power of attorney or an advance directive, I recommend providing those to your primary care physician. Maybe they make them part of your medical record. Your financial power of attorney or your will, maybe let your first or second listed executor or agent know where you keep the originals or provide them a copy if you're comfortable. So keep them somewhere that they can access them if they need to. And then there's a lot that you can do on your own to kind of plan and think through these decisions, but you may run into issues where you really do want to consult with the experts. So call an attorney, particularly I would say an elder law attorney, an estate planning attorney. Plenty of attorneys will prepare wills, but maybe they don't quite deal as much with elder law or long-term care issues. So kind of read through bios critically as you're looking online. Talk to your accountant or your CPA, especially if it looks like you do have a large taxable estate. And oftentimes I'm working with someone's accountant or their financial advisor so that we get the full picture when it comes to planning. So hopefully this kind of triggered some tasks that you can think about, some things that you can do, or maybe you are in a good place. You've already done all this. You can kind of pat yourself on the back and feel reassured you're in a good place. But things to think about and plan for, a little bit of planning now really makes things a lot easier and better for you down the road. So now I'll kind of open it up to any other questions that are out there. And if you don't get your question asked today, I know you can always message our hosts or you can send me a message as well. Give me a call. But otherwise, take advantage. So add any questions in the chat or feel free to unmute and ask them as we go.
Any more questions? Here's Elizabeth's email address and phone number, or you can email us at the lakeshore.cr@eraliving.com and we can forward those to her. But thank you so much, Elizabeth. What an amazing presentation, so clear and precise and very easy to understand. And I hope people learned a lot from it. I'm sure they did. It was really informative. Thank you so much. We will be emailing everyone an evaluation form, and we would love to hear your feedback on this presentation, as well as any suggestions you may have for future presentations via Zoom. And if you have any questions about the Lakeshore or would like a tour, please call us. Our number is 206-772-1200. And just to let you know, 1 week from today, we have another Zoom event. It's Meditation with Carolyn. She's our very own counselor, Carolyn Robinson, and she's going to guide the meditation and lead the participants through a time of deep breathing so you can leave feeling relaxed and refreshed. So for more information on that event or to register, please give Lakeshore Relations, Community Relations team a call. Again, I'm Lisa Alamo, and this concludes today's presentation. We hope you had a wonderful day. We hope you enjoyed it. Have a wonderful rest of your day. Enjoy this beautiful weather, and we look forward to seeing you at future events. So thank you. Take care. Bye-bye, everybody.